What is a conservatorship? When an elderly individual loses the capacity to rationally manage their finances, a judge can appoint a conservator to step in and take control of their assets. The extent of the conservator's authority will depend on how mentally incapacitated the elderly individual is. The court can appoint a conservator to handle a single transaction, such as selling a family home, a limited set of activities, such as paying bills, or the court can issue a broad mandate to manage all of the individual's assets. In a conservatorship proceeding, the incapacitated adult is referred to as a protected person. When is an elderly individual considered to be incapacitated? According to Arizona law, specifically in ARS Title 14, Section 5101, an adult is considered to be incapacitated when they lack the capacity or sufficient understanding to make or communicate responsible or rational decisions concerning their person or well-being. What can a conservator do? A conservator has the same fiduciary duties as a trustee in Arizona. In both cases, the individual managing the assets is required to exercise the same prudent administration that a regular investor would when handling their own assets. Conservators also have a duty of care to the protected person, and they're required to place the needs of the protected person before their own. Considering how conservatorship strips someone of their decision-making abilities, conservatorship should be the final option. It's always better for the elderly individual to willingly authorize someone to take control of their finances. As long as the elderly individual has a sound mind, they can authorize a family member or friend to handle their finances with a durable power of attorney. The power of attorney can offer broad access to their assets, or it can limit the agent's authority to certain assets and activities. A power of attorney can bestow immediate authority, or it can withhold the authority until the agent becomes mentally incapacitated. What is the difference between conservatorship and guardianship? Where a conservator's responsibilities are limited to handling a protected person's finances, a court-appointed guardian is given authority over the protected person's health care, living situation, etc. Guardianships can be limited to certain activities, but most of the time guardians are given a fairly broad mandate to care for the protected person. These protected people are also called wards in guardianship proceedings. Generally speaking, a guardian has the same rights and powers that a parent has over their biological child. If you have questions about whether you need to seek guardianship or conservatorship for a loved one, reach out to our attorneys at Jackson White at 480-618-0351 to discuss your case today.